Tony Pulicella, hello, where are you?
I am coming to you live safely, I might add, for all you legal eagles out there. Parked safely on the Vegas Strip. I had to stop the car and call you and be part of this because of the major happenings that just took place in the last 48 hours, 24 hours. So,
24,
Alan,
24 hours.
24 hours again, the treacherous 10, and it looks like University of Fusky Land is pulling some stuff. So take it away, man. What has happened in the last 24 hours?
All right, so before we get to that, for those people who are wondering, you're in your car on the Vegas Strip. You're not sleeping there, are you? You didn't have a particular bad day at the tables or anything.
No, not a bad day at the tables. I didn't have to hawk everything. I was actually at a major gaming trade show and got stuck in all that glorious F1 construction traffic and finally had to say, this is crazy. I got to pull over and conduct this discussion because it's far more important than anything else. So that's the truth.
Yes, where the Beavers and the Cougars land after realignment is very important. So,
Indeed.
as many viewers may be aware, yesterday the University of Washington filed a motion to intervene in the Oregon State and Washington State lawsuit against the Pac-12. That was expected. In fact, at the temporary restraining order hearing, Oregon State's attorney said if anyone wants to join the suit, we will not object to that. So the University of Washington filed a motion to intervene. The other 9 filed what's called an amicus brief or a friend of the court brief saying, yeah, we're in the same boat. We think the University of Washington's motion ought to be granted. And then they filed a draft of a motion to dismiss, which said if we are allowed to intervene, then we're going to file a motion like this. The only other thing that we really learned from this filing by the University of Washington is that the 12 schools in the conference are part of a formal mediation, and they're using a retired federal judge to assist them. That mediation started on October 2nd, and it is to continue through the end of the month. So we can talk about that maybe a little bit at the end, but really that's all we learned. What no one has talked about, which people didn't notice, is that yesterday the Pac-12 filed a motion to dismiss as well. And this is a motion that will be heard by the court. Shockingly, the grounds for dismissing asserted by the Pac-12 are almost identical to the grounds set out in the University of Washington's draft motion.
Oh, I just don't believe it. That's
Psychic,
just too much of a coincidence.
perhaps. Psychic, perhaps. So, want to talk a little bit about what was set out in the motion. However, I want to start with a disclaimer. I'm not a California attorney. Some of this is governed by California law. I'm not a Washington attorney. And these legal teams have had multiple attorneys they've thrown on this, working weeks probably drafting these motions. And I've only spent a little time looking at it. So I can give you my initial thoughts, but please don't expect a thorough analysis. Basically, in the event this video doesn't age well, I am reserving the right to say, well, I told you I didn't have a chance to consider everything.
To revise and extend your remarks.
So the first reason asserted by the Pac-12, when I say the Pac-12, I'm talking both the commissioner and the conference. But they're saying that they are not the real party in interest. They'll just do what they are supposed to do. This is really a dispute between the treacherous 10 and the remaining 2. There's actually some merit to that.
I was going to say that's actually not doesn't seem unreasonable, maybe, or not out of the realm of possibility. So why don't you explain?
Well, Oregon State got around that argument because this was asserted at the TRO hearing as well. Oregon State got around that argument when their attorney said, well, the Pac-12 is a party because the commissioner tried to schedule this meeting. And so we want you to prevent the commissioner from scheduling the meeting. So why would the University of Washington move to intervene at this point? I think it is because if the University of Washington is added to the suit, there's another defendant, and it might be possible to dismiss the conference and the commissioner. I wouldn't be surprised if this is granted, and if it was granted, it's not the end of the case if the University of Washington's motion to intervene is allowed, and I totally expect that motion to be granted. And in fact, I suspect it will be unopposed by Oregon State and Washington State, and they'll finally consent to it. You say, yeah, let's do that. Now, if the commissioner and the conference were truly just, we're stuck in the middle, we don't know what to do, tell us what to do, that would be the end of their argument. However, it's not. And as I mentioned, it is the same argument that is asserted by the University of Washington in their draft. And that is we don't have all of the necessary parties before the court. Each of the 10 are a necessary party because their rights will be affected by the outcome of this case. Now, they go so far as to say is that this court does not have jurisdiction over 8 of the 10 because they are public universities. One state cannot force another state to litigate in that foreign state. So Washington can't compel the California entities, of course, Cal and UCLA, the Arizona schools. They can't compel Colorado. They can't even compel the University of Oregon to appear in the Washington court because of issues of sovereign immunity. And then because of that, because they don't have the necessary parties there, the motion for a restraining order must be denied. That's their case.
Okay.
However, and there is a question whether California law applies or Washington law applies, but the area here, I looked at it briefly, the law seems to be real similar to Oregon law, which is there's a multi-part test, but the last one is can the moving party, and that's the party moving for the injunction, Oregon State and Washington State, can the moving party receive relief some other way? And if they can't, then maybe the case continues. And so that's one way with which the court could get around this. And I suspect you will see this argued in Oregon State's brief. Interestingly here, they go on to say that when you have a dispute between sovereigns, Oregon being sovereign, Washington being sovereign, California, Arizona, Colorado, the way to bring that case is before the United States Supreme Court.
What?
Okay, yes, according to our Constitution, when there's a suit between states, the U.S. Supreme Court has original jurisdiction. And here's what that means. Normally, the Supreme Court gets to decide whether it wants to hear appeals after they've been tried in a federal court, after they've been heard in one or more courts of appeals. When there's under certain circumstances, they then will say, well, we'll go ahead and review this case as well. And it's up to them. They have discretionary jurisdiction to hear that. That's not true in a case between states. They have original jurisdiction. They have to hear that case. Quite frankly, just as a lawyer, I think that would be fascinating. And Oregon State, Washington State, and each of the other states will go down in history in a type of case rarely heard before the Supreme Court. Uh, that might be a case, though. Be careful what you wish for. If
Uh-huh.
it gets to the Supreme Court, okay, well, now let's make this let's make it worth the Supreme Court's time. Let's bring up some of the antitrust issues. Let's bring this up as a chance to remake the NCAA landscape. But that's possible. I don't think that's what's going to happen, but
Eh,
I kind of like to see it. So anyway, the treacherous 10 are not parties. They can't be made parties. Therefore, the suit should be dismissed.
all right.
Now, the next one is called Let the Pac Decide. And we will get into the particulars of this a little more in the next argument. But in a nutshell, what it is they say, well, there is a different interpretation of what this bylaw means. And there are court cases. I haven't read these cases. There are court cases that say when you have a voluntary association and there's a dispute as to the meaning of the bylaws, it's up to the members of the association to determine what the bylaws mean. I am sure that Oregon State and Washington State's legal teams have anticipated this argument, even if I have not, and I did not see this one coming. And they will be prepared to address that.
Of course.
And then their fourth grounds for dismissal, and I say theirs, the Pac-12 and the commissioner are supposedly two different parties, but
Right.
the treacherous 10 seem to be aren't making the same arguments. Get down to the issue is, what does the notice mean? Does the notice have to be before August 1, 2024, or does the withdrawal have to be after August 1, 2024? And to help with that, I've actually prepared a little slide where we have set out exactly what the Pac-12 bylaw 2-3 provides. Now, don't worry, I'm not going to read the whole thing to you, but I am going to highlight two parts. In the first, it says no member shall deliver a notice of withdrawal to the conference in the period beginning on July 24, 2021, which was the starts of their media right deal, and August 1, 2024, when the media rights agreement expires. And we'll come back to that in a moment, but why is that important? And here we see the highlighted language, which talks about losing the vote and losing the seat on the board. And that's what this is all about. So,
right. And then this, if I'm not mistaken, they're trying to square the circle of what constitutes a notice of withdrawal. Because as we've talked about before, I believe what they're saying is because they haven't formally written it on a school letterhead and submitted it to the conference, it doesn't they haven't technically withdrawn, even though they've said to everybody in the free world they're doing it, and all the conference schedules for the Big Ten have been announced, which specifically shows Oregon, Washington, UCLA, USC, and who they're playing in 2024 in conference.
Well, perhaps the ridicule with which you hold that argument, and with the ridicule with others have also expressed, that has caused them to change their notice argument here. They seem to have abandoned that. And instead they're saying, no, it's not when we give the notice, it's whether we're giving notice that we're withdrawing before August 1, 2024. Well, that doesn't seem to be what the highlighted language above says. No member shall deliver a notice of withdrawal to the conference in the period beginning on. And it sounds like they're talking about delivery of the notice in that period.
Uh-huh.
And you're going to see Oregon State's and Washington State's attorney make reference to that. You're
Sure.
also probably going to see them make some arguments that if it means what the treacherous 10 and evidently our independent caught in the middle commissioner
Uh-huh.
believe, then the rest of it just doesn't make any sense.
Uh-huh.
Because if they are gone after August 1, 2024, then, well, they wouldn't be on the board because they're not here. They would no longer qualify to be on the board. And that means this entire paragraph means nothing.
Right.
Those are the arguments I think you're going to hear.
Fascinating.
Yeah, probably the argument that concerns me the most is the jurisdiction argument.
Yeah.
And these are necessary parties. We can't get them before the court, or we have to bring the case before the U.S. Supreme Court. Well, I suspect Oregon State's lawyers and Washington State's lawyers aren't afraid of going before the U.S. Supreme Court.
No.
I would love to have an opportunity to do that.
Well, any lawyer worth his salt would want to argue before the Supreme Court. That'd be something else.
Yeah, you would think so.
But again, does this not all come back to them really more of almost feels like a stall tactic, if nothing else, for disclosure? Because really, that's, I think, and we've talked about this before, that's the real 800-pound, the 800-pound gorilla in the room. It's disclosure.
Yeah, I don't think it's a stall tactic on their part. This really is what you do in a court process. And one of the things you have to do, if you've ever watched a courtroom drama on TV, they talk about for the record, for the record, for the record. They have to make these arguments for the record. Gotcha. And yeah, I think that the Pac-12's attorneys have filed a worthy motion. There's also the question of whether the court can interpret a contested language or ambiguous language in the bylaws. Now, I don't think that language is ambiguous, and I think this judge probably will hold the same. But that was a clever argument. As I said, that was one I had not anticipated. Everything else we had talked about before, but not this. So now they're in mediation. Surely they've been talking before now, but this is a formal process. They have all month to talk. And hopefully, these conversations include, at least unofficially, the TV network overlords who actually control college sports in the NCAA. And we'll see what happens as part of that.
Well, it is interesting. Again, it's 30 days of back and forth, and letting the process play out. It's strange to me that again, I'm not sure why, other than just being vindictive. I mean, it just doesn't feel like you're leaving. Go. Bye. Okay, we get it. You're leaving. We'll take you can get your share of the revenue that was coming in or due to come in for 2023. We'll give you your part, and then after that, it's our conference to control and to try and rebuild. And I mean, it's just it's fascinating to me. Really.
It's almost as if it's all about money.
Kinda.
Money in college sports.
I know, right?
I thought it was all about the free pickups.
That was something. That was something.
So,
Talk about an NIL deal.
so you were talking about just leave and go. My wife has a saying. She likes, don't let the door hit you where the good Lord split you.
I agree. Yeah. I mean, it's funny because I think obviously it is about money, and it is about the fact that they had their playoff meeting and nothing changed, and it appears that for the next 2 years, starting in 2024, that uh, the Pac-12 retains its P5 Power 5 status with a guaranteed equal split of all the extra playoff dough, which has been estimated at $320 million each
Yeah.
year.
Yeah. Listen, that estimate came from some guy who calls himself miraculous. Is it? No, immaculate. He calls
Immaculate. Well,
himself immaculate, and it was on a Big 12 podcast. And granted, that's a podcast with a lot of viewers. Um, I have tried finding where he got his figures, and other people have tried to find where he's got his figures.
I was able to locate quite a few, actually. So I apologize for not sending those along. Granted, they're estimates, and they were done by, there was two or three that were done by some independent sports marketing and media folks that were able to estimate based on the additional sponsor dollars and TV revenue and so forth like that, what it came in at, what it would come in those 2 years, basically with
So
12 teams and everything else.
I saw an Oregon State official be asked that question, and supposedly a person in the know. No, it's not supposedly. This person is in the know. And they laughed and they said, "Don't believe everything you see on the media or on the internet." So I think the current figures for the 4-team format's been 80 million a conference. I've seen that documented. What happens after that, we don't know. Hey, let me give you 3 dates to keep in mind.
Please.
Okay, so when it comes to the Pac-12's motion, Oregon State and Washington State have until October 20th to respond. And so we'll see what their arguments are at that time. And then the Pac-12 and the commissioner will have 1 week after that to file a reply to the response sent by our 2 favorite schools in the Pac. Okay. So October 20th and October 27th as it comes to this motion. Now, as everyone I think knows, on November 14th is the scheduled date for the hearing on the preliminary injunction. Well, that motion for preliminary injunction still needs to be filed. And Oregon State and Washington State are to file that motion by October 25th. And you are likely in that motion to see the schools repeat an awful lot of what they include 5 days prior in their response to the conference's motion to dismiss. So October 20th, October 25th, October 27th, these are all key dates. Meanwhile, the mediation is supposedly continuing throughout the month. The mediation does not slow anything down. The motion by the conference doesn't slow anything down. This all was anticipated in the scheduling order entered by the court.
All right.
Now, before we go, let me put in a quick plug. This is on the Beavers Behind Enemy Lines YouTube channel. If you like this video, join the channel. Also hit a like. We like likes. And links to these videos are posted on the Beavers Behind Enemy Lines Facebook group. We would love to have you join us there as well.
Now, before you run, there's no reason that they have to wait that long to file, right? The reply. I mean, they could have it ready in 48 hours. They may have already had it ready to go, and they don't have to wait that long, correct? They can just go ahead and file it. We're ready. Here's our reply.
They can, but they won't.
And why is that? Is there a legal reason behind that?
You know, lawyers tend to be procrastinators because we tend to be perfectionists. And if you have an extra week to polish something up, you take that extra time.
All right. Fair
I
enough.
think that's part of it. Another, though, too, is you don't want to give the other side extra time to craft their arguments against whatever you said, as if they don't already anticipate what it is you're going to say.
So that doesn't speed up the reply timeline then. In other words,
No.
okay. So
The only thing
they gave 7 days, but that 7 days doesn't start from when the reply comes in. It starts 7 days from the date their deadline, Washington State and Oregon State's deadline to reply.
well, typically by court rules, at least in Oregon, you would have 7 days from when the response was filed. But when a court sets a scheduling order, the scheduling order controls, not the court rules. So you would they have until October 27th to respond, not 7 days from when the reply was given. Good question. Good question.
Thank you. I have one every now and then.
You're getting in the weeds. One of the people on Beavers Behind Enemy Lines said, yes, they want to know more about this, but do it in lay people language. And I don't know if we've accomplished that, but if you keep asking technical questions, then we surely are going to fail that measure.
I apologize.
All right, well, Tony.
Great
go
to
home.
Talk to you again.
Go
yes,
home.
I shall leave the strip and go to the safe confines of my humble abode, and hopefully we'll get a talk again here in the next week or two when the next round of legal documents arrive and we get a chance to take a look at it.
Well, and I look forward to seeing you in person during the Pac12 championship game.
You can count on it.
Yeah.
When it happens, right? When it happens. And of
That's
course,
right.
Go Beavs, beat the Bruins.
Thanks, Tony. Good night.
Bye-bye.